or, the old saying, with all due respect.
Oh, don't say that with this one here. Oh my
Right.
gosh. Judge Simón would chop your head off.
Right. It used to really
Oh.
mean it was a respectful thing, but now it's like, Judge, it's not very smart. You're not very smart. You're not very.
Because here's the problem with it. He used to say this. It doesn't say how much respect is due. Hello, everybody. It's Rich Rockland. I'm the host of I'll Call My Guy podcast. And I have an in-person guest and a Zoom guest. And I think everything is going to work fine with Julie, who's producing this. I have with me at council table, as we like to say, Judge Jorge Simón, who's retired. Welcome, Judge Simón.
Thank you. Nice to be here.
And I have in Zoom from Martha's Vineyard, I have Judge Linda Prestley, who's also retired. Hi, Judge.
Good to see you, Rich.
Great. So thank you guys for coming in. As you know, I've appeared before both of you guys while you were on the bench, and now in retirement we have a different relationship. Linda works here and is building her mediation business, and you just travel and enjoy your life and stay away from this craziness.
I'm trying, I am trying as much as I possibly can to not get re-involved again in the terms of the business of mediation, arbitration, and those types of things.
Have you done anything at all since you retired?
No.
For
no, I
legal
pretty
wise?
much have stayed quiet, away from the practice.
Wow.
I still have my lawyer. I still have my license.
Right.
I'll never give that up.
You got to pay the money now, the $565, right? Or no, because you probably didn't make any money from it, so you can claim exempt,
right? No,
right?
That's not an issue. The issue is more, I worked so hard to get the license.
Yeah, you don't want to give it up.
I'm not going to give it
You're
up,
gonna die with
no
it.
matter what.
Yeah, I agree with that. That's a good one. So let's just do a little bit of background. So I have Judge Simón. I have your background. It says you were appointed in '96. Is that right?
That's correct.
Right. And you practiced law before, right?
Yeah.
What kind of practice did you have?
Well, I was a prosecutor from '82 until beginning of '87. And then
A state's attorney within Connecticut.
Yeah.
Okay.
Mostly in Manchester.
Okay.
And then I went into private practice for 1 year with Dominic Squattrino.
Oh, I loved him. Oh my God, I miss him so much.
Rick Dyer.
I clerked for him for a little bit.
Yeah, it's a nice
good guy.
group. I was there for 1 year, and we had a difference of opinion about where we should be. Should I be more involved in Hartford than Manchester? So I ended up going to private practice myself in Hartford in the beginning of '88.
So you hung up a shingle and went to work?
Yeah, put up a shingle on Hudson.
Oh, nice.
And I was there until they moved over to Main Street. And then we were there until I became a judge in '96.
So did you go to the state's attorneys right out of law school?
Yeah. Yeah, Austin McGuigan signed me up as a appellate assistant right after I graduated in January, and then he swore me in when I passed the bar in March.
And where did you grow up?
Bridgeport, born and raised.
I didn't know you're a Bridgeport guy. Did you go to like Central High School? Is that what it was called?
No, I went to St. Augustine's Grammar School.
Oh.
And then I went to Notre Dame.
Okay. In West Haven?
No.
Oh, there's
Fairfield.
a Notre Dame in Fairfield. Okay.
Yeah, Notre Dame.
Oh, that's right. There's a Notre Dame in Fairfield.
A much better Notre Dame in
right.
Fairfield.
I lived in West Haven for a while, I know. All right. So you went to Notre Dame. Okay. And then anybody in your family a lawyer or a judge?
No, none.
Wow. So first one.
I was, yeah, first one.
Oh.
Not too many before me went to college.
Right.
So, yeah, first lawyer.
First lawyer, of course, then the first judge.
Yeah.
So you do that. How about you, Judge Prestley? So where did you grow up?
Groton.
You're a Groton girl. Okay. And where did anybody else in the family a lawyer?
Yeah, my older brother, and I remember visiting him at UConn Law School and getting inspired, and the rest was history. He was about 8 or 9 years older than I was, but he kind of set a path for me, which looked pretty interesting. So,
all right. So he does. So you go to UConn as well?
He did. Yeah.
And you did as well. You followed him there.
Yeah.
How about your undergrad? Where'd you do that?
I did that at Hood College in Frederick, Maryland, and in between getting married and having a few babies, and I went to grad school at Harvard, and Then decided to go to law school and, toted my 1 and 3-year-old off to UConn Law and spent 3 years there. And once I came out of law school, I ended up at the AG's office and did child protection and education and CHRO things. And after that, I was appointed the child advocate for the state by Governor Rowland, and did that for a couple of years, and then went on the bench.
So what year were you on the bench?
2000.
2000. So just a little bit after Judge
Right
Simón.
after,
Did you guys
yeah.
ever work together?
I think, we all work together. If you get assigned to a particular branch of the court, like family court, we're always on the phone with each other, picking each other's brains and, trying to figure out how to approach a situation and relying on some of the people who have more experience and helping the ones who have less experience. So, yeah, I don't think we were ever assigned in the same place, were we, Jorge?
No,
Oh,
it wasn't
excuse me,
until
Judge Simón.
assigned. I mean, I think it was until towards the end that we were in Hartford together for a little bit.
That's right. That's right. Yeah.
Oh, that's right. I do remember that. I think you guys were there, but I remember that, right? And then you were out in Rockville for a bit.
Yeah, I went from New Haven to Manchester to Hartford to Rockville, back to Hartford, and then back to Rockville. That's pretty much, my assignments.
Right. And you guys both have a deep history with juvenile work, DCF work, which is, for some of our listeners don't know, is some of the most difficult. I mean, if you think family is trying and difficult, spend a day in a DCF court. I mean, I don't know how you can even, I don't take those cases to me because they're just so heart-wrenching. And sometimes DCF gets it right, and sometimes they overreach. And I know that you had a reputation of smacking them down when they went at it too hard and they overreached, right? I mean, which I think is a good thing. There's a few judges now, not to be named, but they never met a TPR they didn't grant. They just, DCF is they just spit it out. And I think it's very important to have a very strong judge to look at this and say, yeah, you're really getting this right. Because, right.
Yeah, it's a tough balance to strike. I represented DCF in bringing in a lot of those TPRs and so forth. And when I was young and I was very gung ho, and as time went on, you learn that there's not always upsides to permanently removing children from parents. And the pendulum has swung back and forth over the years in terms of reintegrating children back with their parents and keeping them safe. And it's a really, really tough balance. But I love doing some of that work, and I did that for several years. And we became foster parents. Because I was really inspired by and really moved by the fact that kids just didn't have any place to go. And the social workers would come in and they would have just terrible stories about how they had no place to put these 3 babies who arrived at the office at 9 o'clock at night. So we did foster care. We had about 14 kids coming through our house. So I was really able to see it through the eyes of the foster child too. And then I became child advocate after that. So I then saw it through the eyes of how the administration works and how the departments work and how, some of the things they can do better and some of the things they do very well. So, it's been a real eye opener.
So how long ultimately were you on the bench, Judge Prestley?
I was on the bench for 19 years.
And how about you, Judge Simón?
23.
23. Okay. And so, did you have Judge Simón, any administrative roles you did while you were a judge, or did you just sort of keep your head down and?
No, I was the presiding judge for drug court. Then I was the presiding judge in Manchester. Then the presiding judge for community court. Then I was the presiding judge in family.
Right. So you don't get any extra money for that, right? Just more headaches, right?
More headaches than anything else.
Right.
No
They don't give you like a $5,000 boost or something for that.
No, I think they give the administrative judge another extra $1,000.
Oh, gosh, right. You're not worth it. How about you, Judge Prestley? Did you ever do any of those?
Yeah, I did. I was presiding judge for family.
For the
And
statewide?
no, that would be called the chief.
Oh, the
chief-
CAJ, right.
Yeah, the CAJ, right. No, I think it was Hartford at the time, but it was Hartford or Rockville. But yes, that's fine. I think anything beyond that is an administrative headache.
So you did that. Okay, so is it fair to say both of you presided in criminal court?
Yes.
Right,
Yes.
right. And in jury trials?
Yes.
Okay. And then the day-to-day docket?
Yeah.
Yeah, I had the day-to-day docket. I had the pretrial docket. Part A, and B.
So Part A, for our listeners, Part A are the more serious crimes, the
Correct.
felonies, the murders, the rapes, those things.
Correct.
Part B is sort of your day-to-day,
Correct.
anything from breach of peace, misdemeanors,
Your
some
GA.
felonies.
Yeah, the GA
The
work.
GA work. And the GA stands for the geographic area, and they're set up by different areas depending on where you live or where the crime was committed and we were brought in. All right, so let's dive into criminal. So in criminal court, so if I'm appearing, obviously there's a system and there's a process where people come in, they're arraigned, you move cases along, there's plea deals and things like that. As an individual, whether you're with a lawyer or not, let's just say, you're going in front of a judge in some way. Do you, Judge Simón, did you look at how the person comports themselves, how they're dressed? Does that matter?
For me, it did.
Okay.
Yeah, I always looked at the court as being a solemn place, a place where justice is dispensed. And I think that when people came in and they were dressed in a manner or acted in a manner that was, I consider to be inappropriate, not how I would treat them. But they treated the court in a certain manner that I would have a problem with that. Yeah, I did.
Right. And if somebody came in with a suit on, would you, they always, sort of the old adage is, put a suit on because you want to show that you care about the process, that it's respectful. And, sometimes, as you know, some people may not own a suit, right? They don't, and you could tell somebody comes in and they're sort of in their friend's suit and they they try to throw it on, but you looked at it as they treat it with some reverence. It
wasn't a matter to me if they had to be dressed in a suit or in a certain manner. It had to be they were dressed in an appropriate fashion based on whatever economic situation they were in.
I see.
That met a standard.
I see.
If guys came, if I had a policy, I would not let men come into court with shorts.
Oh, fair. Okay.
Okay. So they were sent home by the marshals before they even came because they said, he's not going to like that. Or if I had a woman that came in with shorty shorts.
Inappropriate.
It's not appropriate for being in court.
It's a serious place.
So I would say, or the marshals usually got it first. They would say, there's a thrift shop right across the street, or you can go home and I'll give you a new time to come back or whatever. But you don't want the judge to see you like that. So that was my policy. That was how I acted. I can't say all judges were like that.
But that's not just, again, maybe I'm putting words in your mouth, but it's not just because you're trying to be an asshole to them. It's because you wanted to create a certain decorum and convey that the process is serious and that you have to treat it with that respect, right? I mean,
right.
Is that?
Well, put it this way. It was not only defendants. If I had a lawyer that came up to
the slob.
No, it came up to the bench and they still had their coat on, like a winter coat. I would say, why don't you take off your coat and stay a minute? Or if an attorney came up and their tie was...
Oh, you hate that.
Or the tie was loose and it was...
Say, look at that knife.
So the tie was not properly done, I would say, after he was finished, or I would say, can you come up to the sidebar? And I would turn my back and I would look at him and I would say, do me a favor, next time you're before me, make sure your tie is correctly done.
Right.
Women, I don't think I ever had a problem. I mean,
They just dress better.
I think they dressed better. They had, I think, a different manner in how they presented themselves, because I think women had to work a little harder, and they wanted to.
Oh, I see.
Present themselves.
So they
in
would
a
take
manner,
that. They would take that out of the equation. They wouldn't make that an issue.
very, always very professional.
It's always the guys that were doing this.
Honestly, it was always the guys I had talked to.
How about Judge Prestley? What do you think of that?
Yeah, I think most people for the most part came in and they were reasonably dressed enough that you don't bat a lash at it. And you also understand, I think that, some people were in a shelter the night before and they don't have a change of clothes and they don't have a tie and whatever. Where I really drew the line was, and it was in criminal court, and I can still remember the case of the person coming in who had a major drug arrest and came in and he had a t-shirt on and it was a huge pot plant on his t-shirt. And I said, if you're asking for a program, a diversionary program, so you're not going to have a record, you probably want to go home and come back another time and wear something a little more, a little less offensive given the nature of your circumstances. And they did. I mean, I can remember that happening a couple of times, but for the most part, people, they wear what they've got. And, sometimes people were very well dressed and other times they weren't so well dressed.
Did you take note of that though, if somebody went out of their way to dress nicely?
Yeah, although I found that wasn't necessarily didn't lead me to the conclusion that I was going to be more impressed with them. I mean, I had a couple of restraining order cases where the perpetrator showed up dressed to the nines
Right.
in a tie, and so I didn't worry as much about that.
Okay.
Yeah.
So, all right, and then in terms of, so in the criminal case world, before a trial, there's lots of ways to take off ramps, as we like to say, right? So there's diversionary programs, there's plea deals, and I know that a lot of times that the judges, as the judge was saying, I'm sure you did these, Judge, you pre-try a case, and for our listeners, what that means is you size up the case, you put a value on it. So if it, like for people most likely would know a slip and fall, let's say that's a civil case, right? You say it's worth $10,000 in damages and they try to settle it. In a criminal case, you basically put a number on it. What is it worth? Is it worth a dismissal? Is it worth a diversion? Is it worth suspended sentence? Is it worth how much jail time, right? You give the prosecutor sort of and the defense attorney what you think it should settle for, what should the plea deal should be, right? And then they take it or they go to trial, right? Do you think that, and again, that's completely within the judge's discretion. You're not hearing any evidence. You're hearing basically the prosecutor make their case. The defense attorney is saying, Judge, here's all the mitigating factors here. And this is why I think either you got them dead to rights, but there's mitigating factors, or they're not going to be able to prove their case. How much did you, Judge Simón, put, like did you find yourself, do you think, making a more favorable recommendation to a lawyer that you trusted, that presented himself in a like what types of things that you think would lead you to give a better recommendation, let's say, to a defense attorney, like something that he would like or she would like more so than a prosecutor? In other words, you'd be more lenient in your number because of their advocacy. Like what would you look for that?
No, I think I looked more at the facts. No matter, I mean, I had attorneys in front of me who I didn't like in pretrials, attorneys that I knew in private practice in front of me, prosecutors I knew when I was a prosecutor.
Right.
If I let any of that relationship come into play, that was a mistake. I wouldn't do that.
Well, you could. So as a judge, you were able to learn to do that.
You have to be able to tune that out.
Interesting.
And you have to be able to look at what were the facts of the case, how were they presented to you, and you do take evidence in pretrials,
right? But
you take evidence in a manner that it's condensed,
right? No rules of evidence, right?
You're not talking about 5 days of pretrial. You're talking about 20 minutes, 15 minutes. So you expect them to come in and to be as ready as I am, because I've read the file.
Right.
So they have to come in and they have to tell me something different than what I've read. What is it that happened before the police got there? What happened that led to this particular altercation?
Right.
And then keep in mind that there's always two sides to a story.
Right.
And that it was my job to listen and then, based on what they've told me, determine whether or not it was worth either the number that the prosecutor wanted or the number that the defense attorney wanted, or somewhere in between that I thought was fair. And if I thought the case should be dismissed, I would tell them, this case doesn't
garbage,
belong
right?
here. It doesn't belong here. And I would tell them,
That's
you have a problem.
right. You have a problem with this. And before I get to Judge Prestley, just an interesting point that you made. I wanted you to talk about it, and I want to hear Judge Prestley's experiences too. But the theme of my podcast is I'll call my guy, and what it means is it talks about relationships, and we can get to how relationships can help you in court. Obviously, court is supposed to be a place where your relationship shouldn't matter, right? It shouldn't. It should be, we're going to look at the facts and look at the evidence, and you can't, intentionally don't have relationships with judges because that it's an appearance of impropriety, and you can't do that. So that's a place where your relationships can't matter or shouldn't matter, except in certain instances, and we can talk about that. But what you said was you have to tune that stuff out, because you go in, and I know you get some training as a judge, but as an individual, as a human being that's not a judge, you're susceptible to that, right? Like relationships to me, like somebody comes in, they're very nice, like you hear it presented in a way you like, that influences the regular person. How did you learn to turn that off?
You're not trained in that by judicial. That is just your innate ability to understand what your role is,
right?
To understand what the nature of your job is. Surely there were attorneys that I knew, and during the years I was there, you can come up with attorneys that when they sat down, you knew that they were going to give you a certain type of presentation that you felt comfortable with, versus an attorney that you've known to come in with information that may not be accurate. And that over time, had an impact. So if I knew that this particular attorney came in and presented the facts in a very clear manner, consistent with the report, but then said, look, this is what happened, and I can show that this happened, versus somebody that came in and said, provided information that the state's attorney could show was not consistent, then you keep that in the back of your mind. It's there for the next time. And then you establish that relationship, knowing who's going to be more truthful than not. And that helped. And then sometimes that meant that you had to do the work of the attorney, defense attorney,
right?
Because you knew that now you needed more from that attorney to bolster their case.
And they don't have it.
And they don't have it.
Right. How about you, Judge Prestley?
Well, in addition to the relationships, I think experience really made a difference too. They put at least back then, they put all the new judges, they had a stint in criminal court and in the GA court. And, some of us had never practiced in criminal court as attorneys ever. And that's where, as a new judge, you'd really look to the prosecutor and look to the defense attorney for some guidance as you're sitting in there trying to resolve these cases. And then, you do what you think is fair and you do what you think is right. And I recall one case where the prosecutor was arguing against giving this 18-year-old college kid a diversionary program. They wanted him to have a felony, and he had some bags of weed, and he had been selling in the school, but he was very upfront when he was caught, and he admitted to it, and whatever. And this was an 18-year-old kid. And I think our own experiences having children ourselves and having boys, and teenagers really comes, you can't just put that aside as you're making these decisions. And in that case, I did give him a diversionary program. And, you think about it now and you think, what would his life have been like carrying a felony at the age of 18? But again, listening to all of them, learning as you go along, and then just trying to figure out, as in every other arena, family court or housing court or what have you, doing what you think is fair and just under the circumstances.
But I was asking Judge Simone about particularly turning off that, again, I think that's the sort of default human condition, right? Like people come in, you're like, oh, seems like a nice guy, like the kid who knocks on your door and like, I want to sell you this or sell you a candy bar. Like
Right.
we're always subject to influence, but you have to be, judges really have to do, how did you learn to turn that off?
Well, you have, you apply the facts to the law, but you also have some leeway. So that's where I think all your experiences come into play. And you also learn from it too. A couple of decisions you make early on, you might not make after a year and a half on the bench. I remember it, and this was, if people laugh when they hear this, I had cases coming in and there were crying babies in the GA court, which had 150 people there. And I said, well, let's call the cases with the crying babies first. Well, the next week, 150 crying babies showed up. So you learn. I mean, I had to learn that the hard way, but yeah.
Oh, interesting. And then what about what Judge Simone said in terms of, you get counsel that comes in prepared, that they're not going to take a flyer, they're going to give you representations that you can rely on. Did that stick with you as well? That, again, that's a form of a relationship because it's a credibility relationship, right? The judge, and that's why I'm always looking for that motif, right? Like, that if lawyer X comes in, you're like, when he tells me something, I can take it to the bank because he's never burned me, like, or she's never burned me. Like, do you agree with that as well?
Oh yeah, absolutely. And that happens regardless of where you're assigned as a judge. You get to know the attorneys, you get to know the prosecutors. And for the most part in criminal court, I had very good experiences with the prosecutors and with the defense counsel. A lot of them were seasoned veterans. And you knew when, they would come in and they wouldn't ask for something ridiculous. They were reasonable. So when you've got people who are being reasonable on both sides, it's not that difficult to make a good decision.
Right. All right. In that sense, the relationship that the lawyer establishes over time with the judge, and I know you guys changed locations, but the relationship that you establish by way of how you comport yourself, how you advocate, you're saying, at least as I'm reading it from you both, is critical to how you'll be treated, and your advocacy will be stronger because you are consistently accurate and comport yourself in a way that the judge knows that they can rely on what you say. Does that seem fair?
Sure.
Yes, I think that's fair to say. But I think at the same time, you have to remember that not all advocates are at the same level.
Of course, right.
And
that's right.
Sometimes when that advocacy level doesn't rise to the level that it should, that sometimes you have to step in and ask a more difficult question.
That's right.
That leads you to more of a truthful representation of what happened.
I see. Right, because sometimes, right, I find that lawyers that don't have the experience, or maybe they're just not smart enough, they'll tend to be more fast and loose with things, thinking that's how they're going to get by. And sometimes when you get right, I mean, I see that sometimes and then you sort of say, wait a second, I've read this file. What do you mean by this? And then you box them in, and then they realize, oh Jesus, I can't wing it here. It's interesting. I always talk to friends about this, and I say, when you have a doctor, right? A doctor, and I know you have a son that's a doctor, right, Linda?
Yeah.
Right.
Yeah.
Right. There's a core level of competency with a doctor, right? Because a doctor goes to med school, it's very difficult, and then they have 4 years of being observed, right? So when you make it through all that, even if you're the crappiest doctor, let's say, you still have a core level of competency that's higher than the basic lawyer that just passes the bar, because somebody's watched you for 4 years. Now, granted, they've taken a test and we've taken a test, but at the end of, like, you could literally take the bar exam and then go to criminal court the next day without knowing a thing. So that's why I tell people there's not always fair fights in court, because especially like in the divorce court, you can hire somebody who's a ham and egger, right? Who's just doesn't kind of know, and then you can get the most experienced counsel, and they're both lawyers, right? They both have the same right to be there, but a lawyer that has more experience in that area, that's just has more competency, and there's nothing that evens that out.
No, I think there is.
You do?
I think that when you come out of law school, now, if you have the attitude that you know everything, that's problematic. But if you come out of law school and your attitude is, I'm new at this, who do I have to watch?
Right.
Who do I have to listen to? Who do I have to speak to in regards to how I should proceed with a certain case? When you're sitting in court and you're new and you're watching attorneys, for me it was Jim Wade, UB Santos, Mac Buckley, whomever it was, you're sitting there and you're watching them and you're listening to them and you're saying, that's a really nice way to make that argument. Okay, you put that in the back of your head and you learn from watching. So the same way that someone else goes to medical school and is watched for 4 years, it takes a little time for young lawyers to adapt. I remember when I was in private practice at that time, and a gentleman who is now a judge came into being first year, and he would join the group getting ready to go in line and talk to prosecutors. And he would ask questions. What do you think about this? What do you think about that? And would call you later on and say, I'm here with this type of situation. What do you think? And I think it was our duty, it was our mandate as attorneys with a little bit more experience, just like the ones before us, who gave us advice and guidance for us to guide the younger ones that came after us. So the ones that wanted help, the ones that wanted some direction, you were more than happy to provide that. And then I said there was the ones who thought they knew everything, and they're the ones that really never moved up, let's say.
Interesting. How about you, Judge? What's your experience in that regard?
Yeah, that's been my experience too. The smartest young attorneys are the ones who find a mentor and they watch and see who that mentor is going to be, and then they learn from that person. And they go into court and they watch other lawyers and they watch the good and they watch the bad. And the same thing honestly happens on the bench too. If you can find a mentor as a young judge, or a new judge, you can learn a tremendous amount from people who have had experience and who are seasoned. And my experience also has been that people are really willing to help. They're willing to extend a hand. And, I've had in court, in family court in particular, where, you could see a new attorney really foundering. They just weren't sure what to say and what to do. And another seasoned attorney would step up and whisper in their ear, and then they would make the argument and so forth. So, we happen to have, in many respects, a very collegial group in the family court system, where, people are willing to help each other. But I absolutely agree. Getting that experience is critical.
How about if, there's certain lawyers that, again, this goes back to relationships, that develop a reputation for, they burn a judge, or they act in a way that's just bizarre, or they're doing things that are dishonest or whatnot. Do the judges talk about those things?
Oh yeah, yeah, for sure. Yeah, and I mean, one of the mistakes, if you were to say, okay, well, as a judge, what do you not want to say?
Yeah.
It's the lawyer who comes in who's arrogant and who acts like they're smarter than you are on
Uh,
the and or the old saying, with all due
no,
respect,
that's the oh, don't say
it
that
used
with
to
this one
mean
here. Oh my
right,
gosh, Judge Simone
it
would
used,
chop your head off.
right. It used to really
Oh,
mean it was a respectful thing, but now it's like, Judge, it's not very smart. You're not very smart. You're not very,
because here's the problem with it. He used to say this. It doesn't say how much respect is due. Oh, he would right. I mean, he's saying it now, but he. Oh, you. I saw another lawyer start to say it, and I looked over and I went,
yeah,
and the guy looked at me, and he looked at me, and I said, "Don't say that," because it is. It's a ridiculous thing to say. It's basically saying "f you," and now I'm going to tell
yep,
you why you're wrong. Instead of just
right.
listen, it's all implied that it's all respectful, right? It's supposed to all be respectful dialogue. So when you have this, it's sort of like when somebody says, "I'm going to be honest with you." I'm like, "Well, I did." Well, first of all, I think you mean you're going to be frank with me, but I hope you're going to be honest with me because when you say that, it makes me think like, why do you have to say that? Like, I hope that our conversations
Right.
are all going to be imbued with honesty and good faith. And
And it's the same ones who always do
oh my
that.
gosh, yeah, that's right. Yeah, do not say that to Judge Simone. That's
Yeah.
do not say that.
I don't think I would ever say, with all due respect, counsel. I would never say that to you or
Oh
to,
no, no, no!
to
But
an
if you
attorney.
if you said it, you would stop it like immediately. Do not use that in my because you're right though. I have pet peeves too about that. That's a ridiculous thing to say.
Yeah.
With all due, well, how much is due, counsel? Tell me how much is due, right? It's so. All right, but definitely the judges definitely talk about other lawyers for sure. That's my impression too. That because I've had an experience in Hartford where another lawyer did something, burned a judge. Basically, we had a Kratenstein waiver. We were talking in chambers about certain things, and and the judge opened up to us. It was like he trusted us, and we were halfway through a trial, and we had a Kratenstein waiver, and which allows under the Kratenstein case allows the judge to talk about sort of pre-try the case, even though they're the trying judge, and so you can't move to mistry it or disqualify them. And the judge sort of gave us an insight because he trusted us about kind of what he thought so far, which is great because you never get that, right? And
Right.
we do get good at you appear before a judge enough times. Like there's a bunch of judges I've appeared so much, I know their tells. Like there's tells, and the newer judges usually have more tells, but sometimes the senior judges you learn they look at you a certain way, that they've had enough, or what was your thing? Oh, the glasses, yeah, like enough, moving on. So and he sort of told us like, hey, this is kind of what I'm thinking, and to me, I would love that because it was going my way and it wasn't going the other person's way. And I would use that as to say, okay, if he told me that and gave me that insight, now I'm gonna try something different because it wasn't working. And then that lawyer took it to their client and told the client what the judge said instead of just that's officer of the court talk and I'm just going to redirect things, and then called the judge out publicly on it on the record and I know that after that, I don't know for a fact, but I just know in my heart that judge told every judge in that place, do not trust this lawyer. That has to be the case, something like that, if somebody does that kind of thing.
I don't think I don't think it's always the judges that are sharing the information. I think it's the clerks,
Yep.
the other attorneys,
The marshals.
the marshals.
Yep.
Marshals share that.
It doesn't have to be me telling Judge Prestley that this attorney, this or that. As soon as something happens within the courthouse,
Everyone knows.
it's fodder for everyone.
It is.
Everyone knows what happened. This person said this to Judge Simone or said this to Judge Prestley. Judge Simone just went ballistic and so. So I don't have to go talk to Judge Prestley and say, geez, this guy was a jerk. This is what happened.
She'll just find out.
She'll just come over to me and go, what happened? Why am I getting this report? And then I would say, well, next time this attorney is before you,
Be careful.
Be careful how you present this particular issue.
Interesting. So people should know then that maybe the judges maybe don't intentionally go to each other, but they find out through the grapevine
Right.
and that it'll, if you're acting in a certain way, it's not going to be isolated to that court. People will find out.
Yeah,
Right.
you don't want to prejudice an attorney for perhaps making a bad decision in front of you, that once you've reprimanded them, that they don't learn from that. So if you do something in front of me,
Mm-hmm.
and I reprimand you, or I bring you into chambers with one of the clerks or another attorney, and I talk to you, I don't have to go talk to Judge X, Y, or Z about that.
Right.
I'm hoping that you listened, you understood, and you took my criticism in an appropriate fashion and change your approach.
Okay. Okay. How about you, Judge? What do you feel about that?
Oh, I think we all talk. I think over lunch and over coffee and whatever, we just do. I mean, we talk just like members of the bar get together and they talk about a particular judge who was particularly difficult or unreasonable or wrong. I think that goes on. But I also think we talk about a lot of really good things about how well somebody did in court and
Does that come
how,
up? Yeah.
yeah, how you were really impressed with their advocacy for their client, or how this pro se, self-represented person really put on a great case for herself or himself. So it's, but you do talk about what goes on in court. It's also how we learn.
But good. That's good to know. So if you are, particularly you come in, the lawyer comports themselves in a nice way. They're respectful. They make good arguments. They're prepared.
Yep.
You get positive, discussion as well. The judges would say to each other, "Hey, I just had lawyer X in my court. Really good job. Like, have you ever had him in front of you before?" And did that stuff go around as well?
Yeah, really well prepared. I mean, that's one of the things we always say was, boy, he was so prepared when he came in to do this case. And preparation is probably one of the big things that happens, that you really draw conclusions from how well prepared counsel is, the attorneys are, with respect to their cases. And some come in and you can tell when somebody's winging it, and you can tell when somebody has really spent some time getting ready to represent their client. So.
Because did you guys appreciate, in terms of advocacy, one of the things, again, everyone has their own style. We're all different personalities, and some lawyers are more introverted than others. But trial lawyers generally are type A's. Do you think that sometimes I try to be, and again, it's just my type of advocacy, and I'm curious what each of you thinks of it, is I always offer in the beginning to get off on a really strong footing with the judge, is to say, Your Honor, I've been in this case a very long time. I'd be more than happy to orient the court and get you up to speed quickly on where we're at, to ease the court if you're so inclined. Do you think that's a good method to use?
Yeah, I guess it depends on how you phrase it.
Okay.
Because you don't know. I mean, in front of me, that would work well. I can think of a couple of judges who would say, counsel, no, I know what's going on. I know what's happening and whatever. But no, I think that's a very good approach. The other thing that's, I think, important is, if you're a new attorney and you're new to the courthouse, there's nothing wrong with going in and introducing yourself to the court and to the different judges, and just saying, and it also clues us in that this person is just starting out, that they're going to be learning while they're in court and so forth. But I think it really makes it easier when you end up being in front of a particular judge in a courtroom with a case.
How about you, Judge? Do you like that? If you're just you're working the short calendar, and you're sort of, it's a complicated case, and the lawyer offers to sort of orient the court on what's happening procedurally. Is that a nice gesture?
I think it's a nice gesture for certain circumstances, situations, certain cases. I think attorneys have to assume that the judge has read the file, knows the file to some degree, and has a handle on the case.
So I'm talking when you're like just getting called up, the judge, someone's just working the short calendar motion docket we have now, and it's just, you haven't read a thing. Like, it's just call the case of Simone versus Simone. Counsel, identify yourselves. What's going on, guys? You're like, I'm here on motion 107. It's this. Like you're just doing it on the fly. That's what I meant. Like, not if you've been assigned to my case, you know, like,
No,
you don't like that?
no, I'll be honest.
Yeah.
I read the file.
Oh, wow.
So the day before, I would spend, if you look at the files in family court, the old hand files, you see tabs on all the files. And those tabs all have little dates on them, dates of judgment.
Right.
That was me. I would put tabs on every single file.
So, wow, you were really prepared.
So when the attorneys came in and they said, well, we want to go back to, June of 95 regarding that court order, I would flip over to it and I would find it and I would have made some notes myself.
Wow.
So yes, I appreciated in long cases that have been pending long before I got there to have attorneys more or less do it not so much on the record, but if they came in before court started and they said, Judge, let us bring you up to speed.
I see.
And I say, okay, yeah, fine. Is this consistent with what I know?
Because you were much more old school in that regard. And I mean that in a, it's the joke was, right, we used to say, Judge Simón is not from the old school. He's from the school they tore down to build the old school. But I mean that in a great way because there is, the old school worked, right? It's just a different way of doing it. And you would invite people into chambers. You practiced as a judge in a way that was, you'd come in the back, you're an officer of the court, kind of get me up to speed, what's going on here. And so we can go out and do our, do our thing, but everybody would be on the same page when we went out. It was almost like a rehearsal for theater.
Right. It was an understanding that I don't want you taking up an hour of my time while I have 40 other litigants sitting there waiting for their turn, and you're going to explain the case to me. Understand that I've read it. I understand your positions. Tell me what's changed.
I see.
Tell me where this has gone askew. Why is this motion for contempt here? Okay, let's go argue. Let's go outside and let's talk about it outside. Once they gave me a little heads up about what was going to happen. And I think like any theater, if you've rehearsed a little bit in chambers and you go outside, the attorneys know that, yes, I know some of the facts, but they have a way of putting on their case. They have to be advocates. They have to argue more than what they argued in chambers. So I can listen to that. I can understand that. I can relate with that. They have clients. They have to show that they're working very hard.
That's interesting because a lot of clients don't understand this. That sometimes we go in the back and you look at the judge will look at you and say, Rockland, this isn't this is going to happen. But I said, Judge, I got a job to do, and we go out there and we put on the show. But you're still getting justice. It's just it's not going to go your way for that, and you're not going to go out and say to the client, we're just putting this on and it's going to go nowhere. It's sometimes it's kind of you've made your best case and you have to rehearse that and then go out there and do it.
I think the hardest part for clients to understand is that when you've spent, let's say, a month in pretrials, once a week, once every 2 weeks, and the judge has listened, the pretrial judge has listened to everything, and the judge says, this is what I'm going, let's say you have a Kratenstein waiver, so I'm going to hear the case no matter what. So you've come to me with an understanding from your clients that you're going to argue in front of me, present everything to me, and then listen to what I have to say. And if you don't agree, you're going to go to trial with me. So I would sit there and I would say, okay, Rich, this is what I think is fair. And Julia, this is what I think is fair. And this is what I'm going to do. And then both of you say, I can accept that. That sounds really good. And then you go out and you talk to your client and you say, this is what the judge said. This is what the judge is going to do. And the client says, no, I want my trial. Okay, so now you come back in and you say, Judge, my client disagrees with your, with your opinion about the case. And I would say, well, wait a minute. You all agreed to let me hear the case without trial, to resolve it without going to trial, to save everyone money and time. And now you're telling me that you know what I'm going to do. And unless you come in with something extraordinarily different than what you've presented, which I hope you don't, because that means you didn't tell me everything. But if you're honest about what you said to me in chambers, I'm gonna do exactly what I said. I'm told you what I'm gonna do. So when you tell me you want to go to trial because your client wants to go to trial, I would just look at your client and I would say, you know that we've met. You know we discussed this. You know what I'm going to do.
And your lawyer has put it all into evidence without the rules of evidence.
Right.
Triple, quadruple hearsay, everything.
Yep. Whatever they want to say, they've said in pretrial. And you would say, half the things they told me in chambers
wouldn't come into evidence.
It's not going to come into evidence. So I've already know all the facts.
Well, and I tell people this is only allowed, by the way, if the clients have signed a waiver under the Krattenstein, because otherwise the judge that hears all the quadruple hearsay for purposes of settling a case is typically disqualified from hearing the case for those reasons. But if you sign the waiver, and I use this sometimes depending on who the lawyer is on the other side, if I'm a stronger lawyer than the other person, I get them to agree to a Krattenstein. I'm telling one of my techniques because I think that I am better on a one-on-one without the rule. Of course, anyone, like I sit with a judge, look at them in the eye, and I can advocate to them better this close than 25 feet away at counsel table. And I can put stuff into their head that's truthful, but I can advocate differently because I'm going to be like, Judge. And then the sister's brother who said this, I can put all that in, and I think I'm better at selling it to you there than through the rules of evidence. Much more difficult. So I always ask for that Krattenstein because I think I can do better work, because even if it falls apart, I still got you and it's in your head.
Well, you know what I'm going to do.
No, that's right.
You know what I'm going to say based on what you've argued. So it's now up to the other attorney to convince.
No, but you may not get some of that stuff into evidence.
Well, exactly.
But even you may still do the same thing because in the back of your head, it's confirmation bias. You're gonna try to find what you said you were going to do regardless of the evidence.
It's there. Exactly. It's there. It may not come in, but it's there. It's part of the presentation and part of what you decided to do with everyone's agreement.
Right. I like that. Judge Prestley, what do you think about the pretrial, the Krattenstein?
Well, I think it's always better if you have another judge in the wings who can try the case while you pre-try it.
Right.
Because I think it is really hard to forget what you heard and the triple and quadruple hearsay. And, technically you are not supposed to be considering any of that. I think that's really difficult. So I always found, the Krattenstein, if you're halfway through and you see how a case is going and the attorneys ask if they can meet with me in chambers and they are willing to sign a Krattenstein, even when they come in though, I was always pretty careful about let's not go too far down this road, because if we have to continue the trial, I don't want to, rule myself out as the trier of fact. So Krattensteins are great, and they have, they've helped in settling a lot of cases and saving court time. But I think having another judge who can try the case,
it's ideal.
Completely do the pretrial, and transparency is everything.
I'm giving some of my techniques away, but if I can push through a Krattenstein with another lawyer who's not as experienced,
yes, you can.
I do it all. To me, it's great because you can't unring the bell, man. There's no way. We're human beings. I don't care how Judge Simón has tuned that thing to keep it out. If I've given him all that stuff that's not coming into evidence, that's not leaving his brain.
Right.
Right. So that's a key. That's one of my techniques. So I hope I'm not giving away any of my rules of advocacy. All right. Let's switch to family court now. So we've done criminal and we've touched a little here on family court. Family court is an interesting place. It's where my only forum that I play in, really. I do a little criminal work when it's tied to family. So you get picked up, the cases, right? It
Yes.
starts with husband and wife are fighting, arguing or whatever. One of the spouses brushes by the other spouse. Oh my God, you pushed me. Police get called. They bring in one of the people. The people, then there's conditions of release. They can't go back to the house. They're arraigned the next day. Of course, then the other spouse goes and gets a restraining order as well. And then there's protective orders that issue. And now they're staying on a friend's couch for something small and not seeing the kids. And then you have to go to criminal court. Then there's civil restraining order. And then they initiate a divorce action. Those are the most expensive and difficult cases in terms of starting them and right-sizing them. And so you have those types of cases that come in and then of course somebody then files what we call an ex parte, right? An ex parte, which is, an emergency order for custody that the kids psychologically or physically are in harm's way, and one party wants custody and keep the other parent away. So there's all these different avenues people can take. Let's start about ex partes, because those come up all the time. I haven't been doing family. I've been a lawyer 23 years. I haven't been doing family law for 20 years, but I have a lot of experience. I've done a lot, and certainly not as much as you guys have. But I still to this day cannot tell you when an ex parte will be granted or not, depending on it. I tell people I have no idea. It depends on so many factors. And I think some of them have to do with astrological, like how the moons are lined up or what mood the person's in. Let's start with you, Judge Prestley. What would you look at for an ex parte and whether it should be granted or not? For custody, yeah.
Yeah, okay, so you look at the affidavit, and if you see in the affidavit that they've hit the points of something that rises to the level of imminent risk of serious physical harm, that's for me, then you read it again, and then you read it again. And what I would grant might not be what another judge might not grant it. But I know, for me, I did enough of them to know that if it rises to the level where if I don't sign this, somebody is going to get hurt. Somebody is, whether it's a domestic violence situation or a child abuse situation or what have you, I will grant that. If it doesn't rise to that level, I mean, people sometimes come in and use that as a weapon in a divorce. So, you have to be very, very cognizant of that. Sometimes, you need more information, so you'll give it a hearing rather than just granting the custody. And then that gives you an opportunity, within days later to have them come in and actually put on their case for you. And then you can ferret out more information.
But what about, when you got the ex parte, it would say it was an ongoing case as opposed to a case that starts that way. Did you ever look through the file and kind of see if this is a repeat offender? Because, as you know, some people, again, they use this as a tool, right? They make an allegation. You're just looking at the papers only, right? You're not taking any evidence and somebody's making a sworn statement. And as you know, from family court, things are exaggerated or discounted. So would you look through the file sometimes and say like,
yeah, we had a standing procedure that when an ex parte came in and it was an ongoing case, they would bring the file with the ex parte.
Ah, I see.
So I'd read the ex parte first, consider whether or not I would grant it. If I was leaning in favor of granting it, then I might be interested in what else the file has to say. One of the problems with that, though, is that you are confined to the four corners of the affidavit. So you don't want anything else, but you may have very well seen the case yourself. You may have had it in front of you before. You may know these people. And in that case, you've got more information than just the affidavit.
Did it matter to you at all, at least consciously? Obviously, you can't speak for your unconscious, but the lawyer who brought the ex parte application, did it matter? Did it give it any more credibility if you knew it was a lawyer that was serious and?
Sure.
Yeah.
Sure. If I know who the counsel is and I know that they don't bring ex partes, off the cuff, but I mean, again, you look at the affidavit and you say, yeah, this is really serious. This is very concerning. I'm going to worry all night if I don't grant it. That for me was the measure.
How about you, Judge?
I think as Judge Prestley said, when you get the ex parte request, you get the file, you get you get a list of the previous ex partes that have been filed or accepted or rejected. And then you look at the ex parte and you determine your sense of the credibility of the information that ex parte order has. And I think, as Judge Prestley said, when you have an attorney who seldom files for an ex parte, who's consistently compliant, or whose client is consistently compliant with court orders, that has some impact in trying to determine the facts, because you're not relying on just a pro se,
Self-rep, right?
a self-rep. You have an attorney who is making this presentation on behalf of this client, who you believe has vetted the client in such a manner to elicit what they believe to be truthful information. So you rely on that as well. But in the end, it comes down to how serious do you think the actual nature of the allegations are? And that comes from experience, from,
Right.
how many times has it happened, and, what have you done previously?
I know that a different judge oftentimes hears when they set the hearing and they come in. Were there times where you say, I want this hearing because I want to see what happens here? Or would you follow up later and say, that one I granted, what happened to that? And you check the computer. Would you follow up?
I think that when you're the presiding judge, it's a little easier to keep a case, so that if you have had the file for a period of time and it's been in the court in and out, and the fact, the case, the attorneys, the litigants, and you've issued orders, in most likelihood, I would keep that case. If it was a new pro se ex parte or a new case coming in, I didn't have any problem. That can just go on the wheel for all I care,
Right.
And let someone else make make that decision.
Right. What do you think? What do both of you think about in terms of in custody disputes? What are like one or two things you can think of that are absolute absolute no-nos for litigants to do? What kind of things that would really, you'd say, wow, this person really, there's really issues here that would make you really give pause to, giving them more custody or decision making or something like that? What are the things? A couple things
for an ex parte.
No. I'm switching from ex parte. Just generally, custody litigation. Like if you heard, what do you think?
Sure.
So false allegations, allegations of that there was no proof, or they were so weak, particularly things like sexual abuse of the child, or dad did this, or dad did that, or mom did this, or mom did that are so weak that this has more to do with the custody dispute than it has to do with anybody being in danger. That's always sort of a key. The other one is what they used to call parental alienation. I don't know what they call it.
Refuse and resist, they call it,
yeah. Yeah, where you can make orders, but one parent will do everything they can to defy the orders by mind games with the child, and convincing them that the other parent's the bad guy and so forth, and not cooperating in a parenting situation. Those are the kinds of things that I have a really difficult time with.
Right. So, but in terms of, do you have any advice about or thoughts on, like, those are obviously things that people do, but I'm saying in terms of, like, one of the things, the factors, right? There's a statute, obviously, you can look at in terms of custody. And one of them is the ability of one parent to encourage the relationship with the other parent, right? And to me, when I'm a GAL, I look at that all the time because to me, that's such a critical one. Like, do you say, listen, daddy and I, are not together anymore, but we still love each other. We still love you. We've moved on with our lives, but, daddy is a part of you and he's going to be a big part of your life and we're going to get along for you. Like, if is the parent giving that message, or is the parent, saying, oh, daddy's with his new, hooker wife, like they make these comments about like, oh, he's with his whore, like they say those kinds of things, like, and there's so much hatred and animosity towards the other spouse that it bleeds over to the child. And I always look at that as to me, that's the factor that I give the most weight to. And so I'm just looking for things like that, like things that litigants should avoid. Do you have anything that comes to mind?
For me?
Yeah.
Don't take the child out of state. Don't leave the jurisdiction before, during,
without permission.
Without court permission, you're jeopardizing your ability to properly present a case if you have to be brought back to the state.
So you're talking about times where somebody just takes off to Louisiana to relocate or something,
and they move.
Oh,
and then they file. I mean, that there's been there's been problems, and if all of a sudden someone picks up and they move to Georgia, and then they file in Georgia for a divorce within a few days of arriving there, and you get a call from Georgia, or you get the other parent filing an ex parte
saying, I need a pickup order.
I need you to go, I need my child back. So that is one of those things that I would quickly issue an ex parte in favor. Bring the child back. I'm not saying give it to the other party.
Just get back here.
Just get back here. You get back here and you do what you need to do here, because we have jurisdiction, not Georgia.
That's right.
Or wherever it may be. Then the other thing I really disliked were parties that continually did not comply with orders of the court.
Oh, right.
I mean, you are placing yourself in a situation that you are just antagonizing the court. You're confronting them. You're challenging their jurisdiction. You're challenging their decisions. And I've had numerous cases where that did not end up well for the litigant.
So be mindful of court orders, obviously, be respectful of court orders. And
I just add one.
Yeah, sure, of course.
Yeah. I mean, I always look to see which parent, and sometimes it's both of them, are going to foster the relationship between the other parent and the child. Because in any kind of a shared parenting plan, if it's 50-50 or whatever, it is so difficult, and it's a recipe for disaster if you've got one parent who's doing what you said earlier, really trying to undermine the other parent or make it so difficult that there's no level of cooperation. Sometimes it's one-sided, sometimes it's both of the parties who do that. And, I always remind them, these are your children's good old days, and this is what they're having to watch. Watch mom and dad battle and fight for them and pull on them and pull them in two different directions. Is that really what you want for their good old days? So that for me is...
That's it. All right, I have a couple more things. We only have a few minutes left. For Judge Prestley, did adultery come into how did that impact you? So as just for the listeners that don't do this type of work should know, the court has broad discretion in fashioning awards of how the assets are split, and the court can look at fault. It's a no-fault state, which means you don't have to prove fault to get divorced. It doesn't mean you can't show fault. Matter of fact, we get findings whether or not somebody was at fault or not, or who the fault for the breakdown of the marriage. So you can talk about adultery and those types of things. I will tell you, as from mediating now here with me too, I tell you that I don't see the needle moved at all by judges with those types of things. They look at it, at least in my view, as a symptom of a broken marriage, not something that broke a marriage. Did you feel similarly? Was that your judicial philosophy?
Yeah, I mean, I think adultery used to be a big thing, and that was a big factor in how a case would go. I don't think that's the case anymore, but it certainly is a consideration when you're determining the economics. So if you have a stay-at-home mom who's been home with the kids for 5 years, and and he goes out and meets somebody else and whatever, that's certainly going to factor into our decision to make sure that everybody is as whole as they can be, given what's transpired.
Interesting. Judge
Yeah.
Simone, you agree with that?
No, I would agree.
Right.
I would agree. I think that you look at situations in a manner that is this being, if it's adultery, usually does not play that significant a role in your decision process, unless, as Judge Prestley said, you're looking at a husband with a new trophy wife,
Right.
or a wife with a new trophy husband, in terms of how is the spouse that was innocent of any type of misbehavior going to continue to properly care for themselves or their children, consistent with what they had when both parties were together.
Interesting. All right. So to wrap things up, if you had to give a piece of advice, Judge Simone, to your younger self, the Judge Simone that started as a judge in 1996, what would that advice be today?
Probably it would be to learn to listen more carefully, more intently, when you think that you already know what the circumstances are. Be more open-minded and be respectful of that other side that you may not totally understand.
Interesting. How about you, Judge Prestley? To wrap it up, what advice would you give to young Judge Prestley?
Judge Simone took my answer. I mean, I think I would be a better listener, and not just between colleagues and with attorneys, but also listening to the parties, particularly those who are not represented by counsel, because it's very hard for them to have a voice. Probably a little less judgmental. And I think you tend to be a little less judgmental the more you see. So that things that would have shocked you at the beginning don't shock you so much at the end. But I think being a better listener, that's the best advice for anybody. Because we like to talk from the bench, but we don't like to necessarily listen.
Interesting. Well, Judge Simone, an absolute honor and pleasure. Thank you for coming and giving me an hour of your retirement time, and Judge Prestley as well. I know she's still working, so and works with me. So, but I know both of your times are precious, and this is a little project that I have, but I hope I can share a little bit of knowledge with the community, and I think we have. And so I thank you both very much, and I look forward to the years ahead in your collegiality.
Well, I wish you continued success.
Thank you.
Good luck.
Thank you so much, Rich.
Thank
It's
you,
been a
Judge.
pleasure.
Thank you.
Linda, thank you.
Bye.
Good to see you.